The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. And good afternoon. We have 4 cases that will be submitted to the court for decision. They are Amish Connection, Inc. versus State Farm Fire and Casualty Company, Iowa Supreme Court Attorney Disciplinary Board versus Verla Jean Bartley, State of Iowa versus Hillary Lee Tyler, and then a companion, State of Iowa versus Hillary Lee Tyler. That last matter is submitted now to the court without argument, and we'll first hear the arguments in Amish Connection versus State Farm. Mr. Thomas.
Thank you, Honor. Please the court. I'm Mark Thomas. I have the privilege of representing State Farm in this case. Before I start, I'd like to alert the court to the fact that in preparing for this argument, we discovered that one of the cases we cited, Fidelity versus Nova Casualty, was reversed on other grounds, and that citation I can get to the court in a second here. 726 Fed 3rd 31. I found out last night. The reversal does not affect our position in the case. We cited that case because of the discussion it had about another case called Whiter, which I'll get to in a second. The facts of our case are relatively undisputed. In June of 2010, there was a very severe rainstorm. The plaintiff was a tenant at the Crossroads Mall. They no longer were selling out of the mall, but they're storing stuff in their location. The mall was constructed so that it had an indoor gutter that traveled near the plaintiff's store. The rain fell on the roof. The rainwater went down the drain, and it overwhelmed and broke the drain and flooded the store. The history of the case is that the State Farm moved for summary judgment at the district court level. The argument was that because the policy did not provide coverage for rain, it should be excluded under the limitations section of the policy. The district court agreed with the State Farm argument and dismissed the case. The plaintiffs timely appealed, and the Court of Appeals reversed and decided that the policy defined rain, and that the event in question concerned rainwater, and rain were different events, different terms, and therefore the coverage provision State Farm was relying upon could not support the dismissal. We asked for further review, and that was allowed, and here we are. The standard of review in this case, of course, is for corrections of errors at law. The policy language is, I don't think, disputed. The policy says that State Farm will insure for accidental direct physical loss to property covered under this policy unless the loss is, 1, limited in the property subject to limitations section, or 2, excluded in the losses not insured. And we're talking about the property subject to limitations section. And that section says that State Farm will not pay for loss, and this is in paragraph 6, to the interior of any building or structure or the property inside any building or structure caused by rain, snow, sleet, sand, or dust, whether driven by wind or not, unless the building or structure first sustains damage by an insured loss to its roofs or walls through which the rain, snow, sleet, ice, sand, or dust enters, or B, is the loss is caused by the thawing of snow, sleet, ice on the building or structure.
When does the rainwater become no longer rainwater and just water?
Well, that was we have two briefs and 2 arguments about exactly that position.
How long does it stay rain? That's what I'm trying to figure out.
Well, I don't know if I can discern that in the abstract. I can tell you in this case that if one accepts the idea that rain is only rain while it's airborne and becomes something completely different the minute it hits anything, then the policy actually ensures nothing, because it's akin to insuring against air. And a rain airborne could never harm or cause any loss, because if you say, once it hits something, it's no longer rain.
Let me give you this hypothetical.
Okay.
In the southwest of this country, where there's a lack of water, there's cisterns. And they sit on the roof, and they collect rain, and it's stored, and then pipes bring it through the house, whether to go in the house, probably not, maybe for the washing or toilet functions, or it may go outside. So what if it sits there for a week, and then as it goes through the pipe, it breaks in this situation? Say the pipe went through the house. What is it?
Well, I think that the district court would have called that not rain.
What do you call it?
I would call, under your fact situation, not rain, because it has been stored for a particular purpose, and it is now is akin to a reservoir of some sort. The duration of its existence in a reservoir shouldn't change the nature of what it is. If it reaches a reservoir, just as if it reached a river or a pond or a lake, it would no longer be rain.
What if we change the example now? The cistern wasn't on the roof. It collected just like this. The pipe went through the building, and the cistern was on the ground floor, underneath the house, and it broke. Is that rain, or is it rainwater?
Well, the cistern, if the cistern breaks, and the water that's in
So the pipe going to the cistern breaks.
then I would say if it's coming directly from the storm, it would be rain. Once it reaches the sanctuary, so to speak, for lack of a better word, of another entity, it has to be rain or rainwater. Now, if you can discern the difference between rain or rainwater, which I cannot, then you have another problem altogether. But the point I guess I would make is, in your analogy, the district court posited that same problem and said that it would not be excluded by the policy if it was a situation where the water was stored for some purpose, and that would certainly be in accord with the cases that both sides have cited, where the courts have said, look, if it's in a lake, or if it's in a pond, or if it's in a river, or if it's stored for some purpose, it doesn't matter how long it's been there, it is now something different than rain.
Seem to draw a distinction between surface water and rainwater. So what is the distinction between the two?
Well, I don't. The distinction that I saw in the cases has to do, where they're talking about surface water, is once it's on the ground and it's flowing here and there, they've said that's surface water. Most of those cases do not deal with the situation that we're talking about. In fact, I can only find one, which is that Horizon case, which I'll get to in a minute, that talks about that. But the problem we have in our case is not really a distinction between rain and surface water, it's a distinction between rain and rainwater, because this water never reached the surface unless you're saying...
And it's your position that rainwater is caused by rain, therefore not covered.
Right. And we, I think, our point would be, I think the Court of Appeals missed the phrase caused by rain when it analogized, or when it decided, as it did, that this is not rain. Well, if we say that rain only exists in the abstract between the cloud and the surface, then there's no purpose at all for this section or any other part of this.
Let me just add another
Okay.
thing to my hypothetical.
Sure.
Let's say it's this building and it falls on the roof, but the pipe's clogged, and it's now accumulating on the roof. A day later, because my gutter's always clogged, when the guy pulls the leaves out, the water comes down like crazy. A day later, someone comes down the roof, pulls the clog out of the gutter pipe, and it makes its track down this inside drain, and it breaks. Is that rain or not?
I think that's rain. It's a day later. It's never changed its purpose. It's never been stored for any other reason. It's on your roof because it fell on your roof, and it now is going where it was designed to go to deal with the rain. You aren't storing it for any purpose. You're not using it for your air conditioning. You're not doing anything that these courts are talking about to change the nature or purpose of the storage.
Couldn't State Farm say rainwater?
Well,
Or
they
transportation of rain or something? And see, rain to me means you have a driving storm, and it's hard enough that the wind blows it through a hole in your, one of your, on your roof, you don't have the flashings right or something like that. That's rainwater to me.
Well, let me just answer it this way. If your question is correct, think about it like this. If we're going to make a distinction between rain and rainwater, and you have a house and you decide for the next 50 years you're not going to roof your house, and as the years go by, shingles go this way and that way, and pretty soon there's a pile of shingles in your yard, and there's a hole in your house through which you can see the stars at night as you're laying in bed. A storm comes by and rains right directly through the hole and doesn't touch a darn thing, hits your floor. Now it's a surface. It's now surface water, and destroys your house. You would, under their theory, that would be covered.
But the purpose of the exclusion is to have people maintain their house.
Agreed.
I mean, that's why the exclusion's there, because they don't want to be the people to pay for maintenance, because when you have a leak, you're supposed to fix it. So it's a different situation. This wasn't a leak.
Well, with all due respect, I disagree, because the purpose of the exclusion is to not transfer the obligation to maintain and repair your premises onto the insurance company, so that we're not paying for and covering for maintenance. But in my example, if we accept the idea that rain is only between the cloud and the ground, or whatever surface it hits, and then instantly becomes something else once it hits anything, you would immediately transfer the obligations to maintain your property to the insurance company under that situation.
What's the record say about why the pipe failed? Was there rust or corrosion?
It's a little bit unclear. The records would seem to indicate that the pipe, there was some testimony, some affidavits that the pipe was old and not in very good shape. There was no evidence in the record that it had ever leaked before this day. It's described, I think, by the district court as having exploded.
Are you relying on the exclusion for a loss caused by rust, corrosion, deterioration, hidden or latent defect?
No, we're not, Your Honor. And the reason being, we don't think you get to the pipe because of the limitations section, which means there's no coverage for any event related to rain, caused by rain or snow. So our position would be you never can get there, because there's simply no coverage for this event to begin with.
What about the definition of specified causes of loss, referring to water damage from the accidental discharge or leakage of water or steam as a direct result of breaking or cracking of any part of a system or appliance containing water or steam? Would that include this gutter?
I don't believe so, for the same reason I just mentioned. I think if you took rain out of the equation, you would have coverage. First of all, you get past the limitations section, because you're no longer talking about rain. Now you're talking about a failure of a plumbing system, and you'd have to deal with that provision at that point in time. The whole policy is designed so that first we say, okay, was there a rain event? And in this case, it's the important thing to keep in remember is there's no dispute that there was a huge amount of rain. There's also no dispute that there was no damage whatsoever to the exterior of the building before this event, and this happened because of rain. So the question then becomes, and Your Honor, we're relying on that Horizon case, which is really on all fours with this case, unless you think it's significant that the words resulting from are absent from our policy.
So, I mean, kind of big picture, you're telling us sort of the policy, it's meant to provide coverage at sort of one end where there's like a hurricane and there's a hole knocked in the roof and then rain comes through. That would be unless there's insured damage to the structure or building preceding the rain damage. And it's meant to cover the situation where the water is intended to accumulate for another purpose, like the cistern example, or when I lived in Arizona, I had a swamp cooler or things like that. But in between the sort of routine leaky roof or maybe less than routine leaky drain that we had here, it's not meant to cover. Is that
That's absolutely State Farm's position, Your Honor. That's our position in a nutshell. That we don't believe the policy was ever intended to substitute for the obligation of the property owner to maintain their property. And to the extent that the Court of Appeals and the plaintiff, of course, argue that rain is not the same as rainwater, they achieve that result because they define away any possible I mean, there's no possible way you can get coverage or exclusion if you don't have damage from rainwater. I mean, if it rains and hits the ground and becomes something else, then this policy doesn't exclude it, if that's what we're going to say. Rainwater is, by definition, caused by rain. I mean, that seems to me to be inexplicably obvious. The fact of the matter is, if you look in our brief, the Horizon District Court, U.S. District Court, described the attempt to distinguish between rain and rainwater as tortured semantics, and the Nebraska Court of Appeals said essentially the same thing, that argument makes no sense to either of those courts, and it really doesn't, because rainwater is caused by rain.
Who's at fault for creating the ambiguity that brings us into court today?
Well, I would disagree, I think, respectfully, that there is an ambiguity, because
That there is not?
I don't believe there is.
This is an open and shut case, then.
On our position, the rain is unambiguously, if you remember that the caused by is connected to the rain. You can't define rain and rainwater separate. And I think the cases, and I've got a couple seconds left, but the cases say that if it is truly ambiguous, the ambiguity is construed against the individual or entity that wrote the policy. So that'd be State Farm. But they also say that the courts are not supposed to just strain and reach for ambiguity in obvious situations. And what the State Farm's position is that it's not a situation where rain and rainwater are ambiguous terms. I mean, rain, when you say caused by rain, which is what the policy says, and again, the only distinction between our policy and the Nebraska policy and the Minnesota policy is the words resulting from, which, and, we would argue says the same thing as caused by. The rainwater and rain are the same things, not ambiguous.
Thank you, Mr. Thomas.
Thank you, Ernest.
Mr. Anderson.
May it please the court and counsel. Again, my name is Sam Anderson. I'm here representing Amish Connection today. I think this is a case where, you can argue about rain and rainwater all day long, but you've got to do it within the context of the policy and the policy terms as written from the purpose and the intent that the people have in writing these contracts. Obviously, these contracts are written, states right at the beginning that the State Farm will pay for accidental and direct physical loss. So the thing is, the key there is accidental. Things that are happening that don't go to maintenance issues and whatnot. It has to be an accidental type of loss. And so...
So, counsel, what was the accident here?
The accident is the sudden, unexpected occurrence of the bursting of the pipe. That is not the same kind of thing that you have. Obviously, the clause 6 here that State Farm is relating to, obviously they don't want to cover someone for letting rain fall through their skylight, through their chimney, through an open window, through a leaky roof. Those things you can maintain. You've got a system to keep the water out of the house, and if you don't maintain that system, they're not going to pay for it.
Well, how is that different? What if the roof's not leaked before and then suddenly it springs a leak? Is that covered or not?
I think if the exception to the exclusion, where it says the building or structure first sustains damage to its roof or walls through which rain, snow, sleet, ice, sand, or dust enters. So if there is damage to the roof that's caused by a storm or something unexpected, then I think the exclusion doesn't apply because it's something that is unexpected. If the wind blows the roof off.
But that didn't really happen here. You didn't have the building or structure first sustain damage, right?
Well, you did, because here you've got something within the building it's a water-moving device that suddenly and unexpectedly burst.
But I didn't read the whole thing. By the building or structure first sustains damage by an insured loss to its roof or walls. That doesn't apply here, does it?
No. I mean, because this provision doesn't really apply here because we get back to whether there's any damage caused by rain. I mean, so this doesn't, I don't think this really applies even at all to exclude our situation.
We're kind of back to that where the Court of Appeals was, which is whether this is a situation where there was damage to property caused by rain, right?
Sure, my point earlier when in talking about construction is just the context with which that argument is made. It can't be made in a void, and so obviously it's clear here that they meant rain in this provision, and not meant they didn't. If they would have wanted to put rainwater in there, they could have put rainwater in there, and it would have changed it, and it would have made the exclusion be sort of silly.
Well, Counsel, what language, what specific phrase is ambiguous?
You know, I'm not sure that I'd say that it's ambiguous. To the extent you would think it's ambiguous, it's interpreted in favor of the insured. However, I think rain is rain. I mean, and I think the State Farm has tried to put a silly premise on this to make, we're not saying that rain ceases to be rain as soon as it hits the surface. That sets up a silly premise because, I mean, obviously, here's some examples I wrote down. If you're walking in the rain and rain hits your face, why does your face get wet? Because you're walking in the rain. If you're not wearing a raincoat and your clothes get sopping wet, sure, it's hit a surface, but why are you wet? You're wet because of the rain. At some point in time, things change in vernacular as to what they mean. Rain is water falling down from the sky. After it stops raining, there's water on the ground. That groundwater is no longer rain. No one would ever say that.
Let me ask this question. Say it rains, and most homes have collection systems around them now, that the water runs into a sump pump, and the sump pump pumps it out. It's the ground. It starts seeping through the ground, gets into the sump pump system, and it's collected in the sump pump doesn't get the water out. Basement starts flooding. Is that caused by rain or not?
Well, that's another, in most policies like this one, there's a provision that excludes that. And that would not be rain. I think they'd probably call it surface water. It would be in a different provision altogether that would exclude water from coming in from a sump pump as surface water. I don't think that would be considered rain.
If you don't have a sump pump and it just seeps down and then seeps right through the cracks in your foundation.
Then you've got, you're going to have an exclusion for that in the policy too, because there's not something sudden or catastrophic happening. And if you look to that loss is not insured that Justice Waterman mentioned earlier, they're not going to insure under that. They're for wear, tear, rust, corrosion, fungus, mold, decay, deterioration, hidden or latent defect, or any quality in the property that causes it to damage or destroy itself. So they're not going to pay for the pipe itself that burst. But if the accidental direct physical loss is caused by any of the specified causes of loss or by building glass breakage results, we will pay for that resulting loss. And one of the specified causes of loss is water damage, meaning accidental discharge or leakage of water or steam as the direct result of the breaking or cracking of any part of a system or appliance containing water or stream. So under that provision, the insurance is not going to pay for the broken pipe, but they're going to pay for the damage that was caused by the broken pipe, suddenly and bursting. And so if they're going to cover it there, this other provision also makes no sense. And like I said, if
I mean, that provision would make sense if you read it as that is covering a different set of circumstances, where let's say you're on vacation, your pipes freeze, your pipes burst, and that would be a system that is containing water. But you don't get to that particular definition, do you, about water damage, unless you're already within the coverage, which you would not be if this paragraph 6 applies, right? Or am I misreading?
Well, I don't think Clause 6 does apply, obviously, because this is I think the Court of Appeals was right. I mean, when it says that when this pipe bursts and you're standing under it getting wet, no one's going to say that it's raining on me. That water may be rusty, it may be...
Once the rain hits one surface and then goes along that surface some period or accumulates for some period and then comes down and lands, it's no longer caused by rain?
This was a water channeling device, much like a roof. It's designed to keep water out of the house, or the building in this case, I should say. And so it is containing, at this point in time, it has water in it. I don't know whether you want to call it rainwater, whether you call it rusty water. Whatever water is in there, it's water. It's no longer rain when it's in that man-made channeling device designed to keep water. So when that system bursts, it is water, not rain, that's getting into the place. And it's not within the scope of the things that, if you just look at the plain language of the contract, it's not even within the idea that would be contemplated by number 6. Because if you think, if 6 covers rainwater and not just rain, then the exception to that would be that it would cover rainwater as long as the building or structure first sustained damage by an insured loss to its roof or walls. Well, why not burst pipes if it's rainwater? It doesn't make any sense. A fits with the first paragraph. It's talking about roofs and
So, Counsel, if a tornado blows my roof off
Oh, there we
and
go.
the water comes in, that's covered. We'd agree on that.
Yes.
But what if I have a clogged gutter and a flat roof and it rains a lot and the water pools there, and with that extra weight, my roof collapses? Is that caused by rain and outside the scope of coverage? Or in your view, is that
If it collapses suddenly and unexpectedly,
the roof collapses from the weight of the rain?
I would think so. And here's why. I mean, you look at B, they do cover loss that is caused by thawing of snow, sleet, ice on the building, because in situations like that, you've got the elements are working. You could have a well-maintained roof, and all of a sudden, the ice, snow, sleet are causing something. The elements are affecting your roof. So if
you'd
you had
expand thawing to just rain that's already liquid.
and it's just sitting there, and you've got a perfectly fine roof that doesn't leak, and it bursts, I think this would not exclude it. I think it would be a structure that sustained loss due to.
See, I don't see the thawing there, but
No, I'm just the subpart B talks about the thawing. I'm just saying
Right.
that's another example.
that seems more like, well, but how is that not caused by rain? If you've got the rain water accumulating on your roof and the roof then failing.
Well, it's caused by caused by, at that point in time, an accumulation of water on your in one spot.
So then how do you get past the caused by rain into one of the exceptions to this, to 6A or B, without an insured loss or thawing?
I'm not sure I understand your question. If you've got a, can you ask that again? I'm sorry. I'm not quite sure what you're getting at.
Well, let's focus on provision 6. 6
Okay.
Says there's no coverage for damage caused by rain unless, and then 6A refers to the building or structure first sustains damage by an insured loss. So Here, there's no preceding damage such as the tornado opening a hole in the roof. There's the rain first
okay, I see
cooling
what you're
there.
saying.
6B would work for you if it were melting snow, perhaps.
Yeah,
but
I think that would be a fact determination as to what caused that, you know, whether it was a an insured loss that caused that damage, an accidental occurrence of some kind. If it's not an accidental occurrence of some kind, then no, it wouldn't be. It might depend on the facts.
What does the record show as to the condition of the interior gutter or pipe that failed?
Well, the pipe that burst here, I'm not sure what the record shows. I mean, it burst and it left a crack about a quarter-inch wide, about pretty much the length of the pipe. And the inside, you know, had rust in it, but so we don't know. I mean, obviously, no one would know why that thing was going to burst or expect it. It wouldn't be a maintenance issue other than, you know, maybe you should replace your pipes every so often.
Well, I guess that is, to me, kind of a question that I have. You know, this is obviously, we have a overall business policy that I think is meant to cover all sorts of different entities. So if you have, I own a small business, I own my building, I get one of these policies to cover everything. But isn't this a little bit different situation when I'm just leasing this property from another entity, and their requirement is to make sure that that property is in a good condition so we don't have this situation. Isn't it their drain pipe? It's
their drain pipe,
landlord's
it's their
drain
roof.
pipe. And why isn't your cause of action against the landlord instead of under a business owner's policy that we're arguing about whether it's rain or not rain? Why isn't the real claim against the landlord under this particular case who actually caused the damage? You got a faulty pipe, don't you?
Well, I mean, there is a claim, a viable claim against the landlord, theoretically, depending on what the lease agreement is with the landlord. I mean, obviously, that can limit your options depending on what you've agreed to with your landlord.
And that's what I assume. There's probably something in there that, as part of the lease, I don't know if it's part of the record, but they always put that you must obtain your own insurance for your own losses that may occur inside the leased property. But it just seems to me that the business policy under this circumstance isn't meant to really cover this type of loss for a faulty pipe in the landlord's structure. I don't know.
I would think the lease contract required them to get an all-risk policy, which is what this is. And so, you know, if something happens that's catastrophic, that damages the property within the rental unit, I think that's exactly what this was for. So,
Thank you, Counsel.
Oh, I'm sorry. Thank you.
Mr. Thomas, you may present your rebuttal.
The district court ruled that the argument that there was a distinction between rain and rainwater was not one that she was going to consider following. And that's still the same argument that's being made by the plaintiff in this case, and obviously we've talked about it at some length already, but I did want to bring the court's attention to the fact that, as I mentioned, the Minnesota court in Horizon and the Nebraska Court of Appeals in a case, I can't really pronounce, Espenbar, which both are cited, both address the same argument made by plaintiffs in very similar situations where the assertion was made that this particular language, which says if it's rain or caused by rain or caused by or resulting from rain, if that's the policy that we're under consideration, then rainwater is something completely different. And both those courts said that's an argument that they will not accept because it's such a strained interpretation of real life. And back to the question that Your Honor had asked me about whether we see this as ambiguous, well, that really is the question in this case, is whether a reasonable person would interpret rainwater as being separate and completely different than a phrase caused by rain.
Well, let me ask the question this way then, Mr.
Sure.
Thomas. When your company wrote this insurance contract, what, do you think they had this situation in mind? Was this contemplated?
More than likely. I would think that
Why
something
did
like...
they use the language then that they're talking about damage first has to occur to the roof or the walls?
Well, because...
That's not this case, is it?
No, it is. It is.
It wasn't the damage to a pipe?
Well, let me answer it this way, Your Honor. The reason they drafted this provision the way they drafted is entirely the result of trying to make sure that they weren't insuring for maintenance. And so they said, look, if you're a business or a homeowner and a tornado comes by and throws a tree through your roof, and after that, every bit of rain in 3 counties comes into your house, we'll cover everything. But if you neglect your roof or your house and eventually it starts to leak, we are not going to cover it because there's been no damage to the walls. There's been no damage caused to the walls or the structure by the event.
Well,
so
from a practical standpoint, that all makes sense, and it seems to me when I read the contract language that State Farm had in mind exactly as you described, that if there is damage first to the roof of your home or your structure or to the walls, and then the rainwater enters through that damage, then you're covered. But we're not going to, insurance company's not going to cover if you've just let your roof go and it all of a sudden starts to spring leaks. But how do the facts of this case fit into what State Farm had in mind when they drafted this? That this was a pipe that the insured had no idea was ready to falter. And this isn't the case where the expectation of the insured is that they should have been getting this roof repaired before the damage occurred.
Well, I think that the policy doesn't require clairvoyance on the part of anybody, but what you have to start with, Your Honor, is the fact that this undoubtedly was the result of rain. And the whole premise of the reason that the limitations section precedes the exclusion section is that if State Farm made it a contract which says that if loss is caused by rain, and we again believe that rainwater is caused by rain, then there's no coverage. No matter
The argument can be made all water on earth comes with rain, and anytime you have water damage, it's caused by rain. The real issue in this case, I think, is sort of like the tort issue. You know, how far are you going to go with proximate cause as a matter of law? And the examples you and I played around with earlier, you know, it was just a temporal thing or what the water was stored for. So I understand what you're saying, but I think our job here is to figure out how far remote from the actual rainstorm will we allow the rain exclusion to expire. And I think that's where we are, and I think that's what we're all having trouble with.
and I'm out of time, but could I just say one thing? That the facts of this case, the facts of this case are that this event occurred during or immediately following this rainstorm. So the temporal element's right smack on it, and I'll be quiet. Thank you very much.
Thank you as well, Mr. Thomas. The case then is submitted for resolution, and we'll next hear the arguments in Iowa Supreme Court Attorney Disciplinary Board versus Bartley.